I seriously can't make this shit up. This is real, really. This book, Guilty by Reason of Stupidity, Joel Seidemann. I'm not making this shit up. This is the assistant district attorney in New York, and look at the classic fuck up he made today. I swear, and I'm not kidding about this, I think they're trying to lose this case against Luigi Mangione. The only thing I can possibly believe is that they're trying to lose the case against Luigi Mangione. The colossal fuck-ups that the state of New York and the federal government in New York and pretty much Pennsylvania and everyone against Luigi Mangione, the colossal mistakes that they're making is beyond recognition. I can only conclude they are trying to lose the case against Luigi Mangione. And while it sounds like I'm being tongue-in-cheek, I'm really starting to wonder now, do they want to make a mistake so that... I don't know. Like, I'm trying to figure out, like, they have to be trying to make a mistake. You can't fuck up this bad. Let's take a look. This letter came out today, and I had to get it recorded. Now, I may not publish it until tomorrow morning, but I have to get it today, and I'm going to do a live about it on Friday evening. But I couldn't resist. July 17th, date on the screen. This is a submission of paperwork from Karen Agnifilo, the attorney of Luigi Mangione, to the state judge, Honorable Judge Caro, in the Supreme Court, state of New York, about illegal actions of the district attorney in this case. And for the life of me, I don't understand how many times Karen Agnifilo has to point out that Luigi Mangione's constitutional rights are being violated, and somebody better start giving a fuck in the government. Somebody better start giving a fuck. That you cannot ramrod somebody's constitutional rights in this country because they're a bad guy. Why have rule of law? Karen Agnifilo will point out so many times that what they're doing is against the law, over and over and over again, against the law. She'll make that clear, and it's not wrong. It's 100% correct. Judge Caro, dear Judge Caro, Luigi Mangione, through his counsel, submits this letter to raise yet another significant issue of misconduct on the part of the district attorney. The district attorney has subpoenaed Mr. Mangione's health insurer, and if their account is to be believed, they partially received confidential, private, protected documents that the district attorney readily admits are protected by the Health Insurance Portability and Accountability Act, or HIPAA. Now, again, this is a lot to chew on, what she's stating and what she will state. And Karen is great about not only saying it, but she says it like 12 times, and then she summarizes by saying it again. You can't miss the point of what happened in this article. And I feel like I could cut some of the letter out, but it just is too good. It's too juicy. Karen Agnifilo whipping some llama's ass is what's happening here. All right, so HIPAA, that's what protects your medical information against shit like this, illegal access by people who aren't supposed to have access. And how they got it, most disgusting shit you will ever see. There is no question that the district attorney has no right to possess or review these documents. They did not seek a court order. Nor did they secure a waiver from any party. So they didn't ask Luigi Mangione or his attorney if they can get this information. Moreover, the information is not relevant to the case. There is no reason why what Luigi Mangione was seeing his doctor about his back issues or whatever, that has no relevance to whether or not he shot Brian Thompson. Even if you were to say a motive kind of situation, he had some back problems, it's still, what he went through with his doctor on his back surgery has nothing to do with who pulled the trigger against Brian Thompson in New York City. It had no relevance to the case. I would argue she's correct. Now, you could maybe in some weird-ass stretch go, well, the reason that Luigi Mangione shot Brian Thompson, allegedly, let's not forget that it's allegedly, is because he had back issues and he was angry about it. That's not, by the way, anything that's written in the fucking manifesto they say he wrote. Sorry, I'm dropping so many F-bombs. Yes, it's been a while since I've been able to get excited about a Luigi Mangione news piece. I'm super excited about this one. Okay, so, again, the manifesto, written notes for Luigi Mangione, does not claim that he's mad at the insurance industry because they screwed up his back. That is not why he's doing it. It had nothing to do with that. So again, even if he wrote that manifesto, well, sorry, it's not a manifesto. I've told you that a million times. It's a diary. It's spiral notebook of his personal thoughts. A manifesto is designed to be given to the public. It was not written for the public. It was the law enforcement agencies themselves that made it public. It was the attorney's office itself that made it public. It was everyone in the court system who gave it to the media that made it public. Luigi Mangione never intended for those things to be public, if he even wrote them. And let's not forget, because it's been a while since I've been able to rant on this. Let's not forget that the entire arrest in Pennsylvania was illegal. His attorney said so in Pennsylvania. Karen Agnifilo from New York has said that arrest was illegal in Pennsylvania. And Pennsylvania, the Commonwealth, is like cowards right now and won't rule on it. The judge won't freaking stand up and do their job. I think it's a female judge. I forgot her name. I used to know it. Anyways, she will not do her job and rule that was an illegal arrest. It was 100% illegal arrest. And they continue to use documents and call it a manifesto to say Luigi Mangione is the shooter of Brian Thompson, using evidence that will not come into court, in my opinion. Unless, again, we just throw out the fucking rule book. I'm sorry for the F-bombs. We throw out the rule book in America and stop going by law. We're not a nation of laws. We're a nation of convictions. That's what we are. If we allow this shit to happen, if we allow them to violate his constitutional rights with an illegal arrest and use illegally obtained information against him in a court of law, and then violate his constitutional rights by getting HIPAA information in violation of his constitutional rights, then why do we have laws in the first place? And how do you convict somebody using the law if you're going to break every effing law there is to convict them? It's ridiculous. And yes, I'm on a rant. And yes, I'm pissed off. Moreover, continuing on. Moreover, the information is not relevant to the case. Accordingly, at a minimum, the district attorney has admittedly violated Mr. Mangione's rights under HIPAA and has obtained access to confidential, privileged information. There's a footnote. We'll get to the footnote in a moment. Let's finish the yellow section. We'll go past the purple a little bit to finish the yellow section. No, we won't. Well, yes, we will, because that yellow part right there is actually part of this. The purple part is part of that yellow part. Anyways, you'll see what I'm talking about. I'm going to follow this yellow, and then we're going to skip past this big block of purple. However, the situation is far worse than this. Pay attention. The situation is far worse than just getting HIPAA information. Illegal HIPAA information. Watch how they did it. My God, you're trying to lose this case. As set out fully below, the district attorney's subpoena was false and fraudulent. The district attorney falsely made up a court date. Falsely made up a court date. May 23rd, 2025. That doesn't exist. That court date doesn't exist. He made that shit up to lie to a medical insurance company to tell them we have a deadline of a date that doesn't exist. Made that shit up. This is how far this lie is going to go. And drafted a fraudulent subpoena that if Aetna, the insurance company, did not provide documents on that date by May 23rd, 2025, that it would be in contempt of court. Lied to Aetna. There is no May 23rd date. They will not be in contempt of court because there's no fucking deadline for them to do shit. They lied about it. They lied about it. They told Aetna, hey, there's a court date you must meet. Subpoena you must meet. That subpoena doesn't exist. They made that shit up and then said, you have to have it done by this date or you'll be in contempt of court. Lie, 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 lie. Liar, 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 pants on fire. All right. Then, rather than having Aetna give the documents to the court as required by the already fraudulent subpoena, in other words, the subpoena they wrote said, you need to provide this information that we're asking for to the court system, but they'll do some tricky wording. You know what? You can bypass some of the pain in the ass of putting it to the courts by just sending it to us electronically, and then they'll put pressure on it so that they would obviously send it to them electronically. So they lied, saying you can provide this to the court. Lie, because there's no court waiting for that because it doesn't exist. The date didn't exist. The subpoena doesn't exist. All of it was a lie. And then they gave them an out. Hey, you can provide it to the court or you can provide it to us in email, which of course that's what they got. The district attorney told Aetna to provide the documents directly to the district attorney. Directly to the district attorney. You don't have to take it to the court. You can provide it directly to the district attorney. All right. Intentionally eliminating the court from the subpoena process and ensuring that the district attorney would secure those confidential medical records without either the court or Mr. Mangione's counsel, Karen Agnifilo, knowing or being able to object. Had they followed proper procedures required by law, this grievous error would never have happened. In other words, if they had done it properly and sought a subpoena, Karen Agnifilo would have said, F you, that has no relevance to this case, you can't have it. And a judge would have to say, I don't know who's telling the truth here, the district attorney or Karen Agnifilo, I'll have to weigh on it. None of that happened. They just lied, made up a date of the 23rd, told Aetna that they were under subpoena and that they would be held in contempt of court if they didn't provide illegal information that was not supposed to be given to them because they thought they were doing the right thing. But the district attorney, of all fucking people, I've got a lot of F-bombs today. Sorry about that. Anyways, all right. So that finishes that thought. Let's jump up here to this footnote that goes along. As this court is aware, this is the second time that the prosecution has violated Mr. Mangione's rights by improperly viewing his protected information, having previously violated Mr. Mangione's right to counsel by improperly listening to an 11-minute attorney-client phone call in April of 2025 requiring a member of their team to be removed. Listen to that shit. I told you before. You do not let me. I need an anger translator. I mean, I do pretty good, but I'm gonna need an anger translator. All right. Here's the thing. I told you before when Karen Agnifilo pointed out that she found out that he had been illegally spying on her attorney-client privileged phone calls with Luigi Mangione. They listened in on the phone call. They lied about not doing it. Then they said, okay, yeah, we did it, but it wasn't intentional. And we immediately hung up the phone as soon as we realized it was attorney-client privilege. Then they wrote another letter to the judge. Okay, we lied about that too. We actually did know it was an attorney-client privilege call, and we listened to the entire call, didn't immediately hang up like we told you the first time when we responded to the judge. Hey, what the fuck happened? Well, we hung up immediately. And then they wrote another amended letter. Oh, sorry, Judge. We actually did listen to the entire phone call, and we shared it with other departments. And yeah, we did all that stuff. And then what happened, in case you're forgetting the case, and then what happened is someone recused themselves from the case, stepped down and recused themselves, i.e. got fired or fired themselves. And someone said to me, devil's advocates, yeah, you don't know why that person recused themselves. It may have nothing to do with this. No, it happened immediately after this. After they admitted they got caught listening to attorney-client privileges, someone got their ass fired. They were recused. And then people told me that's not what happened. You don't know why. Maybe they had a conflict with their daughter graduating from school or something like that, and they just couldn't continue with the case. So they stepped down. People recuse themselves all the time for various reasons. But you know what? Here, Karen Agnifilo tells you that when they spied on her attorney-client privilege call of 11 minutes, it required a member of their team, the prosecution, to be removed. It required him to be removed. He was fired, people. He was recused because of illegal activity. That person could have gone to jail for that. Did they go to jail? I don't know. Do we even know who exactly did it? I think I do know who did it. But did he go to jail? I doubt it. But he could have gone to jail. Absolutely could have gone to jail for it, but they had to be removed. Why were they removed? Because by removing them, maybe people will be, okay, well, I guess he doesn't have to go to jail. He was fired. That's the end of the story. But again, some people will tell me, oh, you don't know why he was recused. He might have had a conflict of interest. Conflict of interest is moral ethics. That was his conflict of interest. All right. In addition to these violations, in its June 4th, 2025 response to Mr. Mangione's omnibus motions, the district attorney's office improperly listed Mr. Mangione's social security number, as well as his driver's license number and prior home address. So again, in court documents seen by the public, the prosecution put out Mr. Mangione's personal phone number, his social security number, his driver's license number, and his home address for everybody to see in America. That should have never happened as well. Where civilians who have no connection to this case currently reside. So the home address includes people who are innocent who now are exposed as, hey, this is where Luigi Mangione supposedly lived. Maybe now people will go bang on that door and harass people. Shouldn't have happened. All right, I got to silence my phone. All right. I will try to get through this document, but I'm on a roll. All right. So this is after the district attorney's office failed to redact counsel's personal cell phone number. I told you there was a cell phone in there. I forgot. I was kind of hedging my bet because I was like, I thought a cell phone was in there. Oh yeah, that is. This is after the district attorney's office failed to redact the counsel's personal cell phone number from its now that was counsel's personal cell phone number, the attorney's cell phone number from its April 25th, 2025 letter addressing its improper review of Mr. Mangione's legal call. So in other words, when they talked about the illegal call, they put out Karen Agnifilo's personal number. That shouldn't have been put out there, I think, is what it's saying. Some counsel's personal number. As these four, are you trying to lose this case? As these four examples make clear, the district attorney's office has been cutting corners and carelessly violating Mr. Mangione's rights in its unprecedented and unnecessary haste to try Mr. Mangione's non-capital state case before his federal death penalty case. The state wants to have their shot at him before the federal government. Karen Agnifilo has asked the state to hold off and let the federal government go first, and in their effort to proceed as quickly as possible, they're cutting corners, is what she said. Universal translator for you on that one. All right, let's break down a little bit further. And now this is in blue because it's a slightly different thought, I think. So here we go. Because the district attorney has taken possession of and at least partially reviewed Luigi Mangione's confidential doctor, patient privilege, and HIPAA protected medical records, and further because the district attorney misused the subpoena process, i.e. lied about the subpoena in the first place, to obtain these protected records, this court should impose an appropriate sanction after conducting a full evidentiary hearing to uncover the extent and the nature of the significant privilege and HIPAA violation intentionally caused by the prosecutors. Now, here's what she's saying. You should investigate what happened. But here's the best part about Agnifilo. I'll tell you exactly what happened. I'm going to lay it out. I'm going to spell it out for you. You will know exactly what happened. Now, you can go ahead and do an evidentiary hearing of yourself, Judge, and see what they did. But I'm going to lay it out, and I'm going to tell you exactly where to go to look for all the records, and you're going to find it. So I've done your work for you. They violated the law. Here's where they did it. Here's where you're going to find the record of it, and you should do something about it. All right. Specifically, the defense requests discovery of all the communications, written and oral, between the district attorney's office and Aetna, as well as a hearing where sworn testimony will be taken from, among others, the following people. I want Joel Seidemann, ADA, Assistant District Attorney, who signed the unlawful subpoena, Zachary Kaplan, who reviewed the confidential protected materials received by the district attorneys pursuant to the unlawful subpoena, and 3, the Aetna representative, named in the people's email to the court and counsel, who communicated with the district attorney's office in connection with the unlawful subpoena. There's your names. Here's who did it. Joel Seidman and Zachary Kaplan and someone from Aetna who is not named in this document, but she has it and she's given it to the judge. He doesn't have to do a whole lot of work. Just fucking do your job. That's all. You don't have to do a lot of work. Just do your job. Uphold people's constitutional rights. That's what we're asking. That's all we're asking. If you're going to try somebody in a court of law, how about we actually follow the law? That would be nice. If we're going to try somebody in the court of law, why don't we actually follow the law? All right. Based on the facts developed at this hearing, combined with other violations of Mr. Mangione's rights, including an admitted prior violation of his attorney-client privilege, we ask that the court consider a range of appropriate sanctions to include dismissal of the charges. You know what? One thing that would be right is just dismiss all your charges. You have no case. State case over, will proceed to the federal case. You guys screwed up. You went too far. You screwed up. State case over, dismiss all the charges. She's asking for that. No one's going to allow that. She's asking for it. She has every legal reason to ask for it. I think she has a legal basis. I think that they violated the law. Somebody should go to jail. But do you think anybody's going to go to jail? No, because again, I'm not sure we're a nation of laws anymore. Or they're trying to lose this case. I'm not sure which one. All right. Precluding, this is one of the other options that the judge should have, precluding the people from accessing the HIPAA protected materials that they secured by unlawful subpoena. So in other words, now that you have the illegal materials, have a judge rule you can't use it. You obtained it illegally, you can't use it. God, that seems like common sense. If you obtain something illegally, you can't use it. Like almost like, if you obtain something illegal from an illegal search and seizure of somebody's backpack, you probably can't use that in court. It's like common sense. If you obtained it illegally, you can't use it. Unless we're not a nation of laws and you just fucking break the law anytime you want to when you want to convict somebody. Holy crap, I'm on a rant. All right, here we go. All right, so, and we're going to continue with, and or another option the judge should have, is recusing any member of the district attorney's staff, including the assigned ADAs, from further involvement in this case, i.e. you can fire Joel Seidemann. Thank you very much. You can fire the district attorney. You can fire Joel Kaplan, or is it Joel Kaplan? Who was the other Kaplan? Zachary Kaplan. You can fire Kaplan. You can fire Joel Seidemann. That might start. You can either dismiss all the charges against my clients entirely. You can follow the fucking law, or you can fire some people and maybe send them to jail. But anyways, I digress. Karen doesn't need me to be her English translator, but I like to break down the legal documents for you in my personal language because that's what I do. The unlawful subpoena. Now she's going to break down. Let's take a look. Now she's going to break down the points that she made. 1, and that's going to be all of that. And then she's going to go to 2. That's another point that she made, and she's going to break it down in detail. And then she's going to go to the argument and a close at the end, right? So it's a lot of shit, and it's a lot of repeated information. How much do we want to go through? I don't know. I'm at 19 minutes. I feel like I'm having a good day. I haven't been able to talk about Luigi. Stretch the muscles and go for it, maybe. All right, let's go back up to, where were we at? We were at the 1, right? We were at point 1. We covered all this, and now we're at 1, the subpoena. On May 14th, 2025, ADA Joel Seidemann drafted and signed a subpoena. I don't even know how to pronounce this. Duces tecum? I should have looked that up. I'm not good at the Latin. Is that 2 something? Like duces tecum? I don't know. This is where I need my attorney friend, or I should have done my due diligence. Sorry about that. I'll do better next time. Anyways, to Aetna Healthcare. So he drafted and signed a subpoena to Aetna Healthcare, CT Corporation Systems, 28 Liberty Street, New York. She's even got the address. This is where they sent the letter. The subpoena commanded Aetna to appear before the Supreme Court. Oh my God. You literally told them that they have to appear before the Supreme Court. Illegal, never happened. There was no date of the 23rd. There was no appointment for them to do so, and there was no requirement for them to, but it sounds really scary to Aetna. Hey, I'm the fucking district attorney in New York, and I'm telling you that you need to respond to the Supreme Court. All of that was a lie. All of it. That should bother people. If it doesn't bother you, I'm bothered that you're still here. Why are you watching my channel? You should have you should care about the U.S. Constitution. Anyways, I'm sorry I'm dropping so many F-bombs. Do I want to edit some of those out? Some of you say it's okay, so I'm going to let it fly. All right, here we go. And so it says that you have to respond to the Supreme Court at this particular building. In the subpoena, you've got to appear. Aetna, you've got to appear. You need to appear in person to the Supreme Court at this address, at this court building, on this location on May 23rd at 9 a.m. There is no such date. No such date exists. They made that shit up for the letter. As a witness in criminal action prosecuted by the people of the state of New York against Luigi Mangione, and to bring with you and produce the following items: the account number and period of time during which the following individual received coverage, Luigi Mangione. So they're telling you, we have a right to prosecute Luigi Mangione. You must come to the Supreme Court and provide us the following information: the account number and period of time that he received coverage of Luigi Mangione. Now, on its surface, I will tell you here's the one soft pedal thing that Karen hits a little harder than maybe she should have, but screw it. At this point, if they're not going to follow the law, go for it, Karen. The point being is that technically all they asked for in the subpoena, was the dates of coverage that he was covered and his account number. Still protected information. What they got and how they got it, because they cleverly worded the information, was 120 pages of his personal medical information, including his doctor-client privileged information. It wasn't just a account number and dates of coverage. It was a lot more than that, and they manipulated it to get that information. And that would have been okay if they want to play the game. Hey, we only asked for two things. They gave us too much. That's their bad. But no, when you see that violation of somebody's constitutional rights, you're required to tell the judge, hey, somebody fucked up. We only asked for this, but they gave us this. It took them 8 days. 8 days of having the information and reviewing Luigi Mangione's privileged HIPAA information before they said, we got probably more than we should have got. But they actually designed it to get more than they got. All right. The return date of the trial subpoena of May 23rd, 2025 was not a court date for this matter. There was never a court proceeding scheduled for May 23rd, 2025, nor was there ever a court appearance scheduled for the entire month of May. Rather, this is a completely made up date, which is not permitted by law. In other words, it's against the law to lie and say there's a court date that you must reply to when there's no such court date. No court date existed in May. They lied about it. All right. As trial subpoenas must only be returnable on a court date to the court. There is no court date, so it's a lie. As a result, by commanding Aetna to appear on May 23rd, 2025, and to provide the materials under pain of being adjudged guilty of a criminal contempt of court. They threatened them with contempt of court. If you don't appear in the Supreme Court on this date that doesn't exist, and the time doesn't exist because there's no trial court date on that date, but if you don't appear to this fictional date we just made up, you'll be held in contempt of court and you're going to go your ass to jail, maybe. All right. So, and you'll be liable to a fine. It says file. There's a typo. I caught a typo. Like I never catch typo. I caught a typo in Karen's letter. Somebody's going to get fired in her office. Just kidding. Anyways, and liable to a fine, I think is what it's supposed to say, of $1,000 and imprisonment for 1 year. You think that'll ever happen? Never going to happen. Why? Because laws only are written for the little people. They're not written for the big people. They're not written for government officials. They're not written for district attorneys. Laws in this country are written for the little people. And if you have a good attorney like Karen Agnifilo, maybe you have a fighting chance. If you were a pissant like me, you'd go to jail. Anyways, the subpoena, which was signed only by ADA Seidman and was not so ordered by the court, that's language for the court, right? So ordered by the court, i.e., she even put in parentheses, i.e., signed by this court, was accompanied by a letter from ADA Seidemann to CT Corporation Systems, also dated May 23rd, 2025, that stated that in lieu of appearing, here's where they did the tricky shit. So you need to appear to the Supreme Court in person, or you're going to be held in contempt of court. But in lieu of appearing personally with the requested documents, you may email or deliver them to the New York County Supreme Court, and goes on with an address. The letter also provided ADA Seidemann's office phone number and email address for any further communication. Through this cover letter, the district attorney intentionally eliminated the court from any role in the subpoena process, even though the subpoena calls for medical information from an indicted defendant to go before the court. So in other words, he's like, hey, you have to provide to this court, but you could just reach out to me personally on my phone number or my email and avoid having to go to court and talk to anybody at the Supreme Court. You can just come directly to me. That was designed on purpose to give them an easy out that didn't require them to go appear before anybody at the Supreme Court. So that's part of the design. By keeping the existence of the subpoena from the court, the people also intentionally kept it from defense counsel. Had defense counsel known that the district attorney was attempting to access confidential medical information, the defense would have objected on several grounds. First, the subpoena was a blatant abuse of the process, as the district attorney lied about the existence of the May 23rd, 2025 date as a court date. Second, that the subpoena is an inappropriate effort to ascertain the existence and evidence under Matter of Terry, which is a court case. I'm not going to read all the section numbers. Third, that the subpoena sought confidential medical information to which the district attorney was not entitled as a matter of law. It's illegal for him to have that information without requesting it from the court and having a chance for the defense to argue why that's not going to happen. Fourth, the information sought by the subpoena is not relevant, as the people have maintained that it is a straightforward murder case. All right. By reaching a secret arrangement to have Aetna send the information to the district attorney directly and not to the court, the district attorney ensured that the confidential HIPAA-protected doctor-patient privileged information was not subject to challenge by the defense. So, i.e., send it to me privately, it won't ever go through the court system, and hey, Karen Agnifilo and her fuck-ass team won't find out about what we're doing illegally. As a result, due to the district attorney's intentional efforts to keep the defense in the dark, the defense was unaware of this subpoena for Mr. Mangione's doctor-patient privilege, HIPAA-protected records, until June 24th of 2025, well after the district attorney got those documents, when ADA Zachary Kaplan sent an email to the court and counsel. The June 24th, 2025 email stated that on June 12th, 2025, in response to this subpoena, Aetna emailed the people the next 4 attached files. Now, there is no indication that Aetna sent the materials to the court. Rather, it appears that Aetna sent the files directly to the district attorney by email. Of course they did. That's what the intent was. Bluff, say that you can send it to the court, but then offer them your private email address and say you can avoid some of this shit if you just call me or send it to me personally. Obviously, someone at the district attorney's office communicated with Aetna and told Aetna to email the materials to the district attorney rather than provide them to the court. There's the kicker. And maybe she's guessing, I don't know, but if the clever ruse was, hey, you need to send this to the court, but here's my personal email address, she's claiming they further followed it up by calling somebody at Aetna and saying, hey, just send that over by email, by the way. Don't send it to the court system. So even though we put in writing you could send it to the court system, which would be a major mistake because then it would come through the court system and they'd be like, what the fuck is this? We didn't offer a subpoena. We didn't approve a subpoena. It's like, hey, call them up. You know what? Just go ahead and send that to me privately. That's what she's stating. And I don't know if she knows it for sure. There is an adage that says, never ask a question you don't already know the answer to. But Karen is asking for them to provide all communications between Aetna and the ADA office. So she wants to see exactly what they talked about, including phone call records and logs. So maybe she knows it's already there and she wants them to prove, oh yeah, there's that phone call where she called Aetna and said, or they called Aetna and said, you know what, just go ahead and provide that to us by email. As part of the hearing testimony, we request information as to the identity of the person at Aetna. That's what she's basically saying. And specifically what was said to Aetna. We also request a full copy of the email sent to Aetna and to who it was sent to. Footnote that I'm going to read: on July 16, 2025, we asked the district attorney why it chose the May 23rd, 2025 date as the return date and what, if any, justification they had to choose that date. The office's response was that we're not entitled to that information. Basically, F off, Karen. We don't have to tell you shit. We're the government. We can do whatever the hell we want. We don't have to obey laws in this country. So you can F off. Why do we even have a court system if we're not going to follow the law? I don't even understand this. Further, we request all, this is still Karen requesting information from the court. Further, we request all communication between anyone at the district attorney's office and anyone at Aetna. We notice that on June 11th, 2025 at 4:49 p.m., the court emailed the parties that it was canceling June 26, 2025 as a control date for any outstanding issues. The court administratively adjourned the case until September 16, 2025. So what she's saying is there was no May court date. There was a June 26 court date, but they canceled the June 26 court date. The courts did, because it wasn't even necessary. So they weren't going to have another court date until September 16th. All of this made up bullshit about May is even getting further. There is no court date coming anywhere close to May 25th or whatever, 23rd or whatever hell it's an imaginary date anyways. Who cares what it was? There wasn't a court date until September 16th. For decisions on the motions, in addition to all communications between the district attorney and Aetna, we ask for any telephonic or other communication between the district attorney and Aetna on June 11th, 2025, to prompt Aetna to send the confidential information to the district attorney the next day. So they know that these emails and this correspondence exists, and so she's asking the court to go obtain all that information. We know these emails exist. We know this is what happened. We know the dates that they're doing this. So go get the information, Judge Caro. Do your job. Go look at where they did it, and then maybe fire somebody, dismiss the case, whatever you need to do, but maybe follow the law. That would be good. It is clear that the district attorney utilized a false and fraudulent subpoena to secure those confidential medical documents behind the back of both the court and defense counsel so as to rush this case to trial in a manner that prejudices Mr. Mangione. All right, we are getting closer to finishing this letter. Are you guys hanging in there? Let's keep going. All right, the people's unlawful subpoena requested 2 items from Aetna. So the people, that's the state, their subpoena, which was a fakery, requested 2 items from Aetna. Remember, it was Mr. Mangione's account number and the time period of which he received coverage from Aetna. Seems relatively innocuous. In its June 12th response to this subpoena, Aetna violated HIPAA and unlawfully produced to the prosecution 4 files containing its entire designated record set related to Mr. Mangione. The records were 120 pages of what the people concede was private, confidential, protected medical information within the purview of HIPAA. In addition to being HIPAA protected, the materials are also clearly within the scope of the doctor-patient privilege, as they contain statements made by Mr. Mangione to healthcare providers in order to receive medical care and treatment, as well as medical diagnosis. Indeed, the materials received by the district attorney pursuant to the unlawful subpoena, put the people on clear notice that the materials were in fact confidential and under HIPAA and were privileged, each of which will be addressed below. It's like, in case you missed it, there's no way you could have missed this. You knew you were violating the law. You knew it was protected information, and there's no way you could have missed it. Let me spell it out for you in case you're deaf. All right. The people were on notice that the materials were protected under HIPAA. First, the cover letter from Aetna stated it was from the HIPAA member rights team. The 120 pages you received had a cover letter on top. You can fucking stop looking at that 120 pages as soon as you, oh shit, this is HIPAA information. We can't look at HIPAA information that we obtained illegally. You could have stopped right there. It was on the cover letter. HIPAA, which appeared both on top of the cover letter and as the signature line. Second, the cover letter advised that the materials were to be kept confidential. Why? Because it's HIPAA information, confidential. Third, each of the files sent to the district attorney had in large type, bold letters, request for protected health information. Protected by who? No one's protecting Luigi Mangione's health records. No one's protecting it. If the government wants it, they'll just get it illegally. No one's protecting his health record. So this clear warning was on top of the first page of every file sent to the district attorney. It would be impossible for anyone to view a single page of those records and not immediately see that they were private, confidential medical records within the scope of HIPAA. So even if you want to pull the shit-ass move, well, we only asked for, and what we got was something else, but we didn't know what we were looking at because it didn't say right on the first page, this is HIPAA private protected information. Yet the district attorney's office placed them into discovery file and reviewed them. Placed them into their discovery file and started to review the 120 pages, even though they knew it was illegally obtained confidential information. The people were also on notice that the materials were within the doctor-patient privilege. Virtually every page of the 120 pages of materials received by the people pursuant to the unlawful subpoena indicated different diagnoses as well as specific medical complaints made by Mr. Mangione. They were privileged on their face. In other words, anytime you can see reading the pages that you're talking about a relationship between the doctor and your client, this is where I hurt, this is what I need, this is what I recommend you get, all of that information on face value tells you you're looking at confidential information. Nonetheless, the people received over 120 pages of materials when the subpoena requested only 2 items: the account number and the period of which time Mangione was received coverage. Clearly, the sheer volume of the materials alone should have put the people on an immediate alert that they were unlawful, that the unlawful subpoena that they had served on Aetna resulted in far more material than they had requested. We asked for 2 little simple things. You could have done that in a sentence, in an email, but you gave us 120 pages and I didn't know we were getting more than what we asked for. 120 fucking pages. You did know you were getting more than you asked for. And that because of the nature of the unlawful subpoena, that this material may very well be both privileged and HIPAA protected. Nonetheless, the people are clear that they reviewed the materials, but did not do so in their entirety. We didn't look at all 120 pages, so trust us. We didn't look at all 120 pages. We need sworn testimony. This is what she said, we need sworn testimony to determine precisely what confidential medical files were reviewed, who reviewed them, and when this review was conducted. We also need the computer forensic information of when these files were opened, by whom, and for how long. This is the kicker. No, yes, we need you to admit who did see the files, but because I don't trust you, I need you to also verify if the file was opened, and the computer forensics that showed how long that file was opened, and did you scroll through the pages? Did extra pages go by? Because you're lying and saying you didn't look at it. So I want to know not just your word, hey, we didn't look at it. I want the computer forensics that show when you opened the file, how long you looked at it, when did you close it again, and because let's just be open and frank and honest. On June 16, 2025, a conversation took place. Okay, on June 16, 2025, a conversation took place between ADA, Kaplan, and a named representative at Aetna. This is the only conversation referenced in the email. However, it may not be the only one that they had. So Karen Agnifilo is saying, there's more conversations I know. Get the phone records. ADA Kaplan states that the Aetna representative advised that Aetna mistakenly provided the defendant's entire designated record set to the people. ADA Kaplan further explained that the representative said that the mistake occurred because the defense has served Aetna with a subpoena for the designated record set materials around the same time as the people served the above described subpoena. So in other words, Karen Agnifilo, they're saying, submitted a request for Luigi Mangione's information, and she's allowed to do that because she's his attorney, and he's given her permission to view his medical records. She submitted a request to do that. And so the state submitted their request for the same information at the same time, and Aetna's saying, we got confused. We already got a request from the defense asking for the information, so we figured you probably wanted it too. All right. As of June 16, 2025, the district attorney knew 3 things. They knew 3 things. First, that it had used an unlawful subpoena, where it lied about a court date to get medical confidential privileged HIPAA protected information concerning Luigi Mangione. Second, that the district attorney had the protected materials sent directly to them instead of the court. Third, that the result of this unlawful fraudulent subpoena was a trove of protected medical information that it reviewed and continued to have in its files. Rather than immediately alerting the court and the council, the district attorney's office sat on this information for another 8 days before disclosing that it had in its possession over 100 pages of admittedly confidential privileged medical information. When you realized you made the mistake, or they made the mistake, or whatever you want to lie about, when you realized the mistake was made, you should have immediately said something, not sit on it and review it for 8 days before you go, oh, you know what, we might have got too much information, our bad. Can't let the cat out of the bag, though. It's already done. Now, like I said, Karen Agnifilo repeats a lot of things and hammers it home over and over again, and it kind of is effective when she does so. So I'm going to go ahead and finish this out by reading like the whole letter, because it's too good, and we haven't had anything to talk about for a while. So I need it. It's like an expression of energy, because I feel like this case is ridiculous. We should care about people's rights. So let's go and review the facts one more time, because Karen's already laid it out, but let's review it one more time. There is no question that the people have violated Mr. Mangione's rights under HIPAA by possessing and reviewing the subpoenaed documents. However, the violation goes far beyond this. The violation also involves the intentional and knowing violation of his doctor-patient privilege. In addition, the HIPAA and privilege violations were due to the people falsely telling Aetna that May 23, 2025 was a court date when it was not, and by the people telling Aetna that it provided confidential material to the people directly instead of to the court. The law in this state is clear when it comes to subpoenas. Subpoenas, of course, are a process of the courts, not of the parties. In other words, the defense or the prosecution isn't the one who issues subpoenas, it's the court system that does. While the statute while by statute it is the district attorney who issues the subpoena, and there's that word again that I'm not going to slaughter, the subpoena is nevertheless a mandate of the court issued for the court. So the court issues it, the district attorney may deliver it, but the court has to issue it. That's the way I'm interpreting it. And so she says, this particular law and section makes clear that where the district attorney seeks trial evidence, the subpoena should be made returnable to the court, not to him directly at his email address, which has the right to the possession of the subpoenaed evidence. It is for the court, not the prosecutor, to determine where the subpoenaed materials should be deposited. In other words, the court decides whether it's going to go to the court or to the district attorney directly, not the district attorney. The district attorney doesn't say, you can send them to me personally instead of going to the court. No, it's the court decides where the documents will go. Had the people followed the law, the clear law, she says, had they followed the clear law, again, law only applies to the people you want to prosecute, not to you. So had the people followed the clear law, it would not have possessed and received Mr. Mangione's records that are protected by the doctor-client privilege and HIPAA. Had the people followed the law, the subpoenaed materials would not have been provided to the court, which could have alerted the parties, or would have been, if they had followed the law, it would have been provided to the court, which would have alerted the parties to the self-evident reality that the subpoena resulted in privileged and HIPAA-protected materials. So if it had gone through the proper process, everybody would have had a chance to stop this. But the people refused to follow the law. Moreover, the people refused to follow the law when it came to a subpoena seeking medical information for the indicted defendant. Rather than follow the law, the people drafted a fraudulent subpoena, falsely stating that if Aetna did not provide the documents by May 23rd, it would be in criminal contempt. This was false because, among other reasons, May 23rd, 2025 was not a court date. Yes, she repeats herself a lot. I thought I did. I apologize a lot when I repeat myself. Karen is just like me. Two peas in a pod, only she gets paid a lot better and she's better at her job. Anyways, this was false because, among other reasons, May 23rd, 2025 was not a court date for this case. But rather than waiting for an actual court date, the district attorney simply made one up. It then falsely told Aetna that May 23rd was an actual court date for this case when it knew it was not. This is a lie and a fraud to gain tactical strategic advantage to compel production of medical information as soon as possible. Also, it is a lie and a fraud that the district attorney never intended the defense to know about it. The people further perpetrated this lie and thus and this fraud when it told the Aetna representative that it could fully comply with the subpoena by simply emailing the contents of its submission to the district attorney directly. By doing this, the people moved the court from overseeing this process and ensured that the district attorney did not come into possession of privileged or HIPAA-protected medical information. In other words, you bypassed the court system, which would have stopped this from happening by saying, hey, just email it to me directly. With the courts intentionally being removed from the subpoena process, the people downloaded privileged and HIPAA materials that it should have never possessed in the first place and reviewed them. In addition, the prosecution subpoena is an inappropriate effort to ascertain the existence of evidence, which has been held to be an improper use of the subpoena. And it gives us some legal cases. In particular, the prosecution subpoena was intended to ascertain details about Aetna's coverage of Mr. Mangione. However, the prosecution wanted to get this information by cheating, specifically by ensuring that the defense did not find out that it was gathering the information about Mangione's medical history. This is why they made sure that the subpoena was not so ordered and why it reached a secret deal with Aetna to have this offending information sent directly to the prosecutor out of view of the court and without the court's involvement. After all, the court may have informed defense counsel who would have objected to the doctor-patient HIPAA-protected information being provided to the district attorney. In conclusion, the district attorney's office violated well-established subpoena laws by falsely creating a court date, accepting subpoena records that should have been returnable to the court, and reviewing the medical records that were clearly protected by the doctor-patient privilege HIPAA. Yes, she repeated it again. The defense therefore requests discovery of all the communications, oral and written, between Aetna and the district attorney's office. In addition, we request a full evidentiary hearing by a judge with sworn testimony by all the people who had knowledge of how the subpoena was drafted, how Aetna was directed to provide the information to the district attorney instead of the court, and who reviewed the protected materials, who was told about the protected materials and who supervised this process. In addition, and here's your conclusion, based on the evidence developed through this discovery process and the requested hearing, the defense reserves the right to seek various remedies, including the recusal of the prosecution team. Everyone should be fired on the prosecution team. That's one of the things we would ask. Suppression of the evidence or dismissal of the indictment. You could drop all the charges against our client. You can fire everybody that's on the prosecution team and start your fucking case over again. Or you could just continue to avoid obeying the law in this country and let America see on full display how crooked our system really is. Thanks for listening.